seeing what he saw on this social media page.
You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
phone number one of the comments?
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked that.
I asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous, because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be. I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that. But this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes.
All right, if y'all don't mind talking us through the decision to make a plea and just how today ended up going and transpiring.
Well, this was excruciating because hopefully, in our collective opinion, Jeffrey would have been found not guilty of everything. So this is very painful. But that's another 3 months or so in custody. And he wants to go home to his family. And negotiations totally broke down with the district attorney's office. Horribly broke down. And at that point, we believe that justice would be found with the honorable court. And Jeffrey just wanted to go home. How agonizing it is to know that we've spent a year trying a case where the prosecutors have put on lies, knowing lies, hiding evidence, is insane in 2024 in the United States of America. And the only reason that this got revealed is because of you people. You people brought the truth to the community because nobody knows this. This is not the only courtroom it's happening in, and I just want to thank all of you. I especially want to thank Jeffrey for letting me represent him. I think he's a wonderful person who does wonderful things and will continue to do things even greater. I cannot express to you how Shaquille Kokomo, how Trisha Renard, how Haley, how my wife Colette, how Bram, how countless people, but especially Miss Courtney Edwards, has worked without sleep for 3 years representing Jeffrey and helping him. I will never be able to stand with anyone more ethical, honest, hardworking, insightful, intelligent, and kind than the Honorable Keith Adams. The gentleman to my left is the best lawyer in the country.
Mr. Steele, do you think prosecutors negotiated in good faith at all during any of these negotiations?
Why don't you let me take this one? Let me answer that. The short answer is no. This is a case that possibly could have been resolved if folks were reasonable. But we did not believe that we could enter into good faith negotiations with people who wanted a case resolved in a manner simply to save face. And Jeffrey Williams was not going to say things that they wrote for him, that they wanted him to say, that was their theory when it wasn't true. And so, good faith, no. I don't believe we were ever really negotiating in good faith. And you've been here the past year that this case has been on trial. You've seen the numerous motions for mistrial. You've seen the behavior of the state. You've seen the dishonesty. You've seen everything being hidden. You've seen things come out in court, in front of you. And so you know what kind of prosecution we were dealing with, and that's okay. You know, Mr. Steele and I have fought through this the past 2.5 years. And as he said, we ultimately decided we were going to put our faith in the court as opposed to the folks on the other side of the aisle. And, you know, the best thing out of all of this is that Jeffrey Williams, in a very short period of time, will be home. And that's all we've wanted from May 9th, when they went and picked him up and have held him in jail without a bond for the past 2.5 years. He'll be home shortly.
Keith and Brian, this either one of you can answer. So I have 2 questions for you. First off, you go into a blind plea, you don't know, right? There's nothing for sure. What was your emotions like when you guys went into that? I would imagine the conversation, can you kind of take us into the room before you went out into court, what the conversations were back and forth? Obviously, I know there's attorney-client privilege, but it's a big decision.
Well, I didn't want to give up the jury trial, but that was a decision made, and once that decision was made, we were just thankful that there are people like the Honorable Judge Whitaker who understands what a trial is like and what it should be like. And I cannot thank the Honorable Court for being here and coming in. She is not our first judge, but she's the first time we received justice.
Mr. Adams, this is your second high-profile RICO case here in Fulton County. Do you think that maybe the prosecutor's office is abusing that statute? And what are your opinions of RICO generally?
I have, for the 30-some-odd years that I practiced law, always believed that if you, as a prosecutor, think that someone has committed a crime, you charge them with the crime, you put it in front of a jury, and then you do it fairly and let the chips fall where they may. The courtroom is not the place to get adventurous, to get inventive, to think, well, we don't have evidence on him for any of these incidents, but maybe, if just maybe, we tie him up in a RICO and put him with people who may have committed crimes, we can get him that way. That's an abuse. And so, yes, for some strange reason, the Fulton County DA's office seems to be in love with RICO, and my honest opinion is that they're in love with it because it makes it easier for them to try and convict people that they otherwise could not convict. And that's what was happening here. We're fighting a mountain, reams of evidence, most of which didn't have anything to do with us. And so, is it an abuse? I think it is. There are better ways to, and I used to be a prosecutor, right? And I can tell you that there are better ways to prosecute cases than the way this case was prosecuted.
You guys obviously rejected initially what the state was going to offer. Is there some details you can give us? Because it sounds like from what you guys decided in court, I mean, it's still pretty stringent. There's a lot of different details, but what was the state asking for that you guys rejected?
I'm not going to get into plea negotiations because they are privileged under statute, but it was outrageous. They would let him out of custody, but they would have a tether around him so tight that it's unconscionable.
And how are y'all feeling about what the sentencing is, especially with not being able to be in Metro Atlanta except for specific parameters, and how is Mr. Williams feeling about that decision?
You know, we're okay with the sentence. There comes a time in any case, if a person is sentenced, that we're out of the courtroom, and now what happens to that person is entirely up to them. One of the questions you asked a little earlier was, what was that feeling like, stepping into a courtroom to do what's called a blind plea, not knowing what's going to happen? You know, it's a scary feeling for all involved. There's probably no feeling quite like that other than sitting in a courtroom waiting for a jury to come out and tell you what your fate is. But we walked in there knowing that we were in front of a fair tribunal and being comfortable that the right thing was going to happen, and the right thing did.
The DA's office has just made a mess out of this whole thing.
In Fulton County, the trial of rapper Young Thug and others named in a sweeping RICO indictment could be steps closer to a mistrial. On Monday, motions filed seeking to recuse Judge Glanville from the case were granted by Fulton County Judge Rachel Krause.
If this new judge comes in and the lawyers argue for mistrial, they have a legal basis for it.
Defense attorneys filed the motions claiming Glanville showed bias toward the state after it was revealed in court he met with prosecutors and their witness Kenneth Copeland after Copeland refused to testify the day prior.
6. I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
let me tell you, I'm just reading from it, but if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critial part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we
that leads to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1, Paragraph 12.
You've already said that. You've already said
Georgia Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Lowe.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Lowe.
Okay, excuse me.
Okay. All right.
There are instances where you can have an ex parte communication, but one of the requirements is that you notify the defense immediately about that. That did not occur.
Lester Tate, a former president of the Georgia Bar Association, says another key factor in the decision was Glanville's defense of his actions.
You don't defend yourself, and that's one of the things that she put in the order.
In her ruling, Krause said while the court has, quote, no doubt that Judge Glanville can and would continue presiding fairly over this matter, preserving the public's confidence in the judicial system weighs in favor of excusing him from the case. Manny Aurora, a criminal defense attorney and former Fulton County prosecutor, also unrelated to the case, says he believes she made the right decision.
Almost sort of strong-arming the witness to testify and the defense not knowing about it and the government being, present. It just leaves a very bad odor.
As far as how Jeffrey's feeling now, he knows my feelings, which I'm not going to reveal for attorney-client privilege, but this is not the same as a not guilty verdict. That should have been rang. But nobody here wakes up every day on a concrete floor that they're calling his bed, gets up at 4:15, gets shackled at his feet, his waist, and his hands, comes to the Fulton County Courthouse to be on concrete, eating out of a bag. Doritos is his meal of choice. And then coming to a courtroom and sit there with a leg chain on him every single day and hear lie after lie. So for Jeffrey, go home today and not have another 90 days or 120 days of it, he is very happy, thankful to the Honorable Court. So to answer your question, this was not what I wanted. I don't believe that it is just, but I believe that under these circumstances, it is justice for Jeffrey Williams, and he is delighted, as are we. I'm thankful.
You called out a lot of challenges in this trial based on the prosecution's points. Do you have any message to, the co-counsel that for now is still on trial, or what's left of this?
Oh my God, they are phenomenal lawyers, and I'm confident if you keep going, which I assume you will see some great lawyering. They don't need my help.
And the truth is, they've been there with us for the past 2.5 years. They're aware of what they're up against. They are totally capable of handling it, and I presume we'll step in from time to time because, in this fight in the past 2.5 years, we've been together. So we needed something, they've been there to assist, and if they need something, we're happy to step right back in and assist. But they're great lawyers. Max Shard, Doug Weinstein, those gentlemen are in great hands. They'll be fine.
I will say this, I think it is wrong, and it needs to be fixed, that an innocent man is arrested on May 9th of 2022, is denied bond, and has to plead guilty and nolo to get freedom after 2.5 years in custody. That should not happen. Nobody should be on trial. Jurors, think about what they're going through. Nobody should be on trial like this. And if Mr. Williams didn't have the resources, this never happens well for anybody. So I think it's an abuse of the statute of RICO to do this to people.
Is it fair to say you don't believe justice was served today?
I believe that Mr. Williams is home, and I'm delighted. Justice would have been served on May 8th of 2022 if the grand jury no-billed his indictment. That would have been just. And it's wrong to be under investigation. He's been under investigation for 15 years. 15 years by task force of federal government and local government. Think about that. Think about your children doing that. And that's okay. If it's okay with you all, then we should really start moving to another country. I want to thank everybody so much for everything you do. I cannot thank you all, because without you guys, this just keeps rolling in injustice. It's got to end. The criminal justice system, the presumption of innocence, the Brady rules, the ethical rules, they have to survive. Otherwise, we all are victims of this. Anyone can sit in that seat next to Keith Adams. Thank you all so much.
And no one sees it unless you guys do what you do. But I tell you what, there is a whole world of people out there who have watched this trial over the course of the past 2.5 years. The past year that we've actually been in the courtroom trying the case, who are much more educated to how things work, and unfortunately, sometimes how things don't work. Thank you guys.
Thank you, everybody.